Greetings and salutations, everybody. So we're going to start in just a moment with today's class, which is going to be playing by the rules, legal considerations in kink and BDSM. So just give us a quick moment and we'll be ready to get underway. Alrighty. All right. Well, good afternoon, everybody. Greetings and salutations. My name is Ogun, and I am the alpha boy of the House of Steel. And today we are going to be talking about the law and legal considerations in letter, and as well as kink. So, in light of today's class, before we begin into the nitty gritty, into all of the meat of the discussion, I wanted to have an important conversation that is very, very important in light of what is going to be happening on Tuesday. And in light of that, I wanted to tell everyone it is very, very important for you to vote in light of the upcoming election. In a lot of states, early voting has already ended. And so, in light of the early voting period already ending in a lot of states, it is very, very important that you ensure that you are appropriately registered to vote and that you do go to the polls on Tuesday and make the appropriate decision to protect the democracy and to also protect your rights as a citizen of the United States. And if you're not watching from the United States, it's still important to remember that voting is very, very important to any part of the democratic process. So if you are registered to vote, go out to the polls and vote on Tuesday. And in addition to that, make sure that you vote with intention and vote with your mind and spirit clear as possible. So keep that in mind as you move forward into the next week. And without further ado, we're now going to start today's lesson. So today we'll be presenting about legal considerations in kink and BDSM and what does this mean? Now it's important to talk about leather and the law together as one entity. And many people don't think about them together or don't think about them in terms of interacting with one another. Well, with respect to the law influences everything that we can do. It influences our rights, it influences our ability to go forward and to act in whatever way we deem fit. And it also covers and also ensures that we're able to not get arrested or not to get locked up, or we don't have certain things that will happen to us because we have the appropriate protections afforded by a law, a statute, or even our Constitution. So it's important to have these discussions about what is permissible and what is not permissible so that everybody's able to play safely and also to be able to play within the bounds of what the law allows for. Now, before we get into the important part of this conversation today, I also wanted to just frame some things that are very important to the conversation that we're going to be discussing and also frame our objectives. So first, the object of today's class is to give you an understanding of how aspects of BDSM and kink interact with the law. As I mentioned earlier, the law impacts everything that we do. It impacts how we walk about the world and show up in the world. The second objective is to provide a snapshot of the general state of the law. Now, one thing I will let you know is that I am a legal practitioner who is licensed to practice in the state of Georgia. However, there are 49 other states and numerous other territories in the United States of America. And so I'm providing the general state of the law. And what I'm providing also cannot be used as legal advice, but general purpose for education. So please keep that in mind when you're listening to today's discussion and also interacting with us and asking any questions. I can't give you specific legal advice, but I can provide information to educate you. And then lastly, it is to remind everyone of things to consider when engaging in BDSM and kink activities. Again, the law lays the foundation and lays the framework for the rights that we have and the things that we can and cannot do within society. And so essentially, we need to keep that in mind as we're going about our practice of kink and BDSM or going about the way how we engage with one another in the community. So without further ado, this presentation will also not give you legal advice specific to your state. So as I mentioned earlier, I'm only licensed to practice in the state of Georgia. And so this will not provide legal advice to your specific situation or your specific state. So use this as a tool. And also keep in mind that if you do have specific legal questions that are relevant to your state or relevant to your situation, you can find an attorney in your state who is licensed to provide you that information. And at the end of this presentation, I will share with you an important resource that the National Council of Sexual Freedom has provided to allow kinksters and polyamorous people to seek legal representation in their state. So now we're going to move on to the two major elements of today's discussion. Now, first and foremost, there are two major elements of the law that people need to consider when they are talking about anything BDSM and kink related. And the first is the criminal context, right? So, for instance, what laws can potentially influence criminal prosecution or a finding of criminal culpability or criminal responsibility in the event that something does happen? And then the second part is the civil ramifications of what we do as kinksters and leather people and people who do BDSM. Exactly what are the civil ramifications of some of the things that we do, whether it be that we create a contract for a dynamic, or whether it be that we do something that, includes additional agreements to engage in certain types of activity. It's important for us to know that these two major elements both make up the major components of the law and also will frame our discussion today as well. Now, again, as I mentioned earlier, there are 50 states in our country, and then there are also multiple jurisdictions that are considered territories, and each of them have their own specific rules. And if you're listening from outside of the United States, additionally, your local country or jurisdiction also has its own rules regarding what can and cannot happen and what is allowed and what is not allowed. So it's all about the when and the where, and you got to keep that in mind. So this chart that I'm showing on the screen actually is a map of basically showing where certain BDSM activities are considered to be allowed or may be considered criminalized, or if the law is just not really clear about it. This map shows the contiguous 50 states and exactly what is the law potentially with regard to how the state will go forward in prosecuting crimes related to assault or battery when in relation to consensual BDSM and kink activities, or with respect to certain types of legal protection with respect to BDSM and consensual kink activities. So again, you always have to keep in mind about where you are and when it is that you are engaging in these situations, and that in each state, the when and the where is extremely important. Now, the first thing I want to start out with, though, is a very, very important discussion because before we even get into the specifics of the law and what the law has to say about any potential criminal responsibility or civil responsibility, the foundation of everything that we do starts with consent, and it starts with FRIES. So FRIES are basically a short and quick acronym to talk about what consent is. And consent is freely given, reversible, informed, enthusiastic, and specific as provided by Planned Parenthood. This framework is very, very important to understand exactly what consent is, and everything that you do is based on consent. Now, if we're talking about consent in the terms of what is it and what does it actually mean, consent actually has two definitions according to Merriam-Webster and Oxford Dictionary. And consent also can take on the form of a verb and a noun. So consent is a verb because we act based upon it. When you consent, you agree. You make a mutual agreement to engage in certain sorts of actions or certain sorts of discussions that can allow you to forward a specific series of actions to reach a certain result. So that is the verb version of the word consent. And then what does consent mean as a noun? Well, it's a principle that we all should think about. It is a thought process, and it is a way to describe the process in which we both, me and the other person, or you and the other person, make agreements to try to proceed forward in engaging in specific activities. Now, why is consent important? Consent is the legal foundation that all sexual conduct and contact occurs in. It is the foundation of any sort of engagement and any sort of relationship, whether it be platonic, whether it be friendly, whether it be sexual or romantic, or whether it be in a BDSM and kink dynamic. It is required for all acts and people every single time. And again, it can be very freely given and taken away. So consent should never automatically be implied. You should always check to make sure that consent is present for everyone, for every single thing, every single time. Now, there's a couple of different things that people often say about consent. And they say, well, consent's permanent. And once you give it, you can't take it back. That's false. Consent can be changed or altered at any given time. People have the right to take a step back and say, yes, but not in this way. Or they can say, okay, well, I consent to being flogged, but I don't consent to being flogged on my front. I consent to only being flogged in the back. You can narrowly tailor your consent, you can expand it, and you can adjust it. But you have to be very, very clear about that revocation or that expansion or that contraction of consent. So that way you are able to not have any issues with respect to playing or with respect to engaging with the other person. You also need to make sure that consent is something that is always required, no matter where you are. Some people say that if you're in certain types of spaces, whether it be a bathhouse, a play space, a sex party, or a dalliance party, or you name it, it's still required that consent is present in those sort of interactions. There are still rules in place that require how people are supposed to engage with one another. And if you're not engaging with people appropriately, then what ends up happening is that you can potentially find yourself in a lot of trouble. And then, there's some people that say, well, consent is a defense to certain types of conduct. Well, that's actually not always true. And we'll see later on in the presentation that for public policy reasons, you cannot consent to certain illegal activities or crimes, but states vary. And this basically talks about, the concept of what constitutes a crime, what constitutes a criminal act, and based off of what the law of that state says, does this fall into that framework of actually being a criminal activity? Is this assault? Is this battery? What is this? And so again, it varies by state and it varies by the approach that the state or the jurisdiction takes in prosecuting crimes and also looking at how they treat consensual BDSM and kink activities. Now, who cannot consent? The presumption is that if you are able to be mentally capable of making sound decisions, you can consent. But there are people who universally cannot consent no matter what. Even if the person says yes, they still technically cannot consent as a legal matter because they do not have the mental capacity as understood by law. And these three particularly that are listed are general across the board in almost every single jurisdiction. So if you're unconscious or incapacitated, you cannot consent. The reason why you cannot consent if you're unconscious and incapacitated is because you cannot appreciate or understand or acknowledge what is going to happen to you. You cannot understand or appreciate the decision-making potentially that's going on. And if you're unconscious and incapacitated, more likely than not, you're also not able to actively be involved in the decision-making process about what you wish to do or how you wish to play. So you cannot consent if you're unconscious or incapacitated. Now, the next category is minors. Minors cannot consent. There's multiple reasons why minors cannot consent, and I put an asterisk on this for multiple reasons. So minors cannot consent for a couple of different reasons. Number one, they're minors. From a psychological perspective, minors are not able to appreciate fully what is going on. In addition to that, also the law is very clear that when someone's under the age of 18, they cannot engage in certain types of activities, or in certain jurisdictions, it's 21. If someone's under the age of 21, they cannot engage in certain activities. And it's the implication that the person may be trying to use substances or alcohol. So sometimes there is a bit of variance, particularly in the age of what is considered a minor in certain places. In the United States, generally the rule is 18, but in some instances, it sometimes can be 21. It just varies. I always err on the side of caution that for me, a minor is defined as anybody under the age of 21 for multiple reasons. But in addition to that, it's also just important to consider that with a minor, you can get in extraordinary legal trouble, even if someone is considered to be 18. depending upon your jurisdiction, that if you do not appropriately get that consent from someone who's reached the age of majority, you could automatically be found in violation of whatever law that is applicable in that location. So please, please, please be careful with respect to that. And the last category, which is extraordinarily common, is intoxication or being intoxicated. If you are an intoxicated person, or if you are drinking, or if you're using substances, then the issue then becomes you cannot consent. The reason why you cannot consent as someone who is intoxicated is primarily because of the fact that you're, again, not able to appreciate what is going on. And some people have very clear rules about, well, what is intoxication and what is not. For me, intoxication is if you are drinking any alcohol, or if you're smoking weed or any other substance, right, that's potentially illicit, and it alters your mental state. That is intoxication. So generally speaking, the rule of thumb is that if you're engaging in kink or BDSM play, you should never, ever, ever be under the influence of any substance while engaging in play, for a couple of reasons, mainly for safety. You cannot appreciate what is happening to you if you are intoxicated. You cannot feel things the way how they're supposed to be felt if you are physically and mentally altered due to a substance. And so you cannot consent safely because you are intoxicated, because your mind state is not at a baseline where you can function normally. So you have to please keep that in mind, that these are the three types of people that cannot consent under any circumstances. And please be careful if you run into any of those three. Additionally, you need to make sure that you are vigilant with respect to also intoxication specifically, because some people may use a substance or they may decide to drink alcohol, and they may not necessarily appear that they're intoxicated. But you need to check and see if the person has used whatever item or substance, so that way you are aware of what you're walking into before you walk into it. Now, there's a new approach to consent. We have fries, but this is another framework that a lot of people have been using recently, and it's called the explicit prior permission model. The explicit prior permission model kind of takes the same approach as fries, and basically it requires that you have to agree to specific acts and the intensity. So, for instance, part of this would be if you're deciding to get flogged by somebody, you're saying, hey, I want to get flogged, and I want this flogging to be a 7 at the most. That is basically you setting the specific act that you want to do and the peak intensity that you wish to experience it. The second thing is that you need to make sure that you're of sound mind. Again, this goes back to whether or not you are able to consent, you are able and have the capacity to engage in that conversation and negotiation, so that you're able to play and able to appreciate what will happen and plan appropriately for what may happen. The third part is that you can agree to seriously injure someone. You cannot agree to seriously injure someone. And this goes back to what I said in the true and false slide. There are specific rules about what is avoided for public policy reasons. And so, in light of that, they say, with respect to how people play, they may play hard, right? And they may want to engage in edge play. So you have to really have to have a conversation about what constitutes a serious injury, and then what could potentially go in line with what you're going to be engaging with. And highlighting a comment that was made by Peg just a moment ago, there are some people that talk about their risk profile. Again, the serious injury conversation is about talking about what's within the risk profile. So I'm glad that Peg did bring that to our attention. And honestly, I thank you for providing that insight, because it's very important that when you're weighing risk, it also will guide your consent and negotiation process. Now, with the fourth point, you have to agree what role play resistance is okay to ignore. So again, this goes in line with safe words. This goes in line with, whether or not you're going to be engaging in certain types of play that may restrict certain kinds of communication. There are some people who may decide to engage in bondage as a play activity. And so, resisting against the restraints, depending upon how that process could look, it could be seen as a normal part of the role play for someone who's engaged in bondage to resist against the restraints. But if they're saying a safe word, then that basically means that there's something going on that requires the scene to stop, or it requires the scene to slow down. And then the last one is you must have a way to stop at any time. Again, it goes back to having built-in safeguards with respect to your negotiation, making sure that you have the appropriate safe words in place, and knowing exactly what can and cannot happen within the context of your kink or BDSM activity. So those are really the 5 parts of the explicit prior permission model. Now, before we transition into the next phase and next segment, talking about the criminal considerations, it's very important to note that, again, consent is very imperative and the cornerstone of anything that leather people, kinksters, or practitioners of BDSM do. You must have that consent. And without it, nothing can move forward. So always make sure that you have open and honest conversations about your capabilities and what your wants are. Be very clear about what you can and cannot do. As Peg mentioned, do the appropriate risk assessment. And also make sure that you check the person's risk profile to ensure that they are comfortable with doing certain things. And in addition to that, have conversations about your safe words, about what your limitations are in terms of play, how long the duration is going to be, and other items that are extremely important to your safety in engaging in that process. Now, with respect to your criminal considerations, which is the next part of our presentation, there are 3 major points that I want to touch on for today's class. And the first is about battery and assault laws that apply in jurisdictions, public decency laws, and then the constitutional laws that sometimes can also fall in line as well as this, because the Constitution actually does guide a lot of our criminal jurisprudence in this country and whether or not certain things are deemed criminal activity or not. So without further ado, we're going to roll into the assault and battery laws. And assault and battery, people sometimes think they're the same thing. Sometimes people believe that they have the same definition. And legally, they are different. They're distinct. So assault is the threat of touching or unlawfully touching someone. It is basically putting someone in fear of apprehension of a potential physical injury. In other words, it's about the intent and the perception of what's going on from a mental perspective. Someone is watching you do something and there's a threat that something will actually happen. With battery is the actual act of touching or unlawfully touching someone else without consent. Or beyond consent, because sometimes what happens is that if you're reading the law in certain states, it'll say without consent, but sometimes it has to be implied that there are certain types of battery that are allowed based on consent or based on context. So a very good example of this would be boxing or MMA fighting. Technically speaking, assault and battery, those definitions would apply in both of those instances if someone's competitively fighting or they're doing something where they're physically hitting someone else. But there are allowances that allow for that because of sporting reasons or because of other types of reasons. So again, it just depends upon what the law of the state says and how the courts of that state interpret it. But generally speaking, battery is the actual act of physically touching someone else in a way that is considered offensive and harmful to that particular person. And while both of these are crimes, they're also civil causes of action. You can actually sue in most states for either one of these and also sue for damages in relation to either one of these. So for instance, if you happen to be assaulted and you have a mental injury, you could seek mental assistance and then get monetary recovery for that. For battery, the same is also true. If you're physically harmed and you have medical bills or some sort of, need to financially recover due to that incident, then you can by having a civil cause of action for battery. Now, what I can tell you is that the general legal theory in the United States as of 2015, based on kink and BDSM, is that consent is not a recognized defense to assault, even when based on a claim of consensual sadomasochistic activity. So this is a case that was ruled on in California. And California has a reputation for particularly being very liberal when it comes to sexual rights and sexual freedom in comparison to a lot of other jurisdictions. But in light of the Court of Appeals issuing this ruling in 2015, it took a very, very strong stance saying that consent is not a recognized defense to assault, even when based on the claim of consensual sadomasochistic activity. And the reasoning is based on the language of the case opinion, is that they don't want to open the door for using that as a defense because people can overuse it as a defense. Now, as a legal practitioner, I have my own opinions regarding this. I don't think it's a slippery slope as much as they would say it is, because the reality of it is that when there is consent, it's very, very specific and it's there. In order for you to engage in consensual sadomasochistic activity, as indicated by the case law or the language, you have to engage in very clear, upfront discussions. And so, as a result of that, sometimes the concept of a slippery slope seems to be more hyperbolic than anything else. So, as a legal practitioner, my position on this is a little bit different, but the law is what the law is. And a lot of states have kind of taken a position regarding this based off of how things have looked with respect to a lot of our legal jurisprudence. So there's actually two extremes when it comes to how courts approach this. So the traditional approach is that prosecution will occur in an instance of a consensual, sadomasochistic, or kinky sexual activity, right? And if the police get called, then the prosecution can actually prosecute the case in some traditional jurisdictions that follow a traditional approach. It's often based on sexual assault or battery laws. Some other states also use sodomy laws as a way to also try to enforce this on the back end, even though, as we'll talk about later, the sodomy laws and the way how those are interpreted have been effectively changed since 2003. But generally speaking, the way how the traditional approach looks at it is that they will still prosecute on sexual assault and battery. And the concept is that the state has an interest in protecting people. That's what the court's rationale is for taking the traditional approach. So based on the People versus Davidson case that I just mentioned, the consent to BDSM and kink activities is not recognized due to that traditional approach. Now, the modern approach is a little bit different. So there is a code called the Model Penal Code, and the Model Penal Code has been updated quite a bit, and some states have adopted it. But the Model Penal Code's approach is slightly different in certain iterations, and it doesn't take a look at prosecution as the way forward to handle these situations. The reason why they don't prosecute on the modern approach is because it's based on privacy rights. So, in other words, the state has an interest to protect citizens, but the state also has limitations on how to police intimate sexual relations and sexual activity. So, in other words, it goes back to the Lawrence versus Texas framework that we'll talk about later on in this presentation. The state can regulate things to protect citizens, but it can't be so deeply involved in the private aspects of a person's life that they can completely block out or criminalize certain things. So, as a result, on the modern approach, the consent to BDSM and kink activities is recognized, and it is clearly there based on how the courts will approach that situation. Now, some people may ask, well, why is BDSM and kink even criminalized in the first place? So this goes back to what we discussed earlier, and it's about the health, safety, and morality reasons that the court may sometimes have to try to enforce some of these laws. So the state has an interest, again, in protecting health and protecting safety. But there also have been arguments that have recently rolled about in the court system about morality, especially in the federal court. There have been some federal cases that have come up in the last 5 to 10 years that do address the morality and how the position of morality affects how the court should take a specific position. So with respect to why BDSM and kink is criminalized in a lot of jurisdictions is because they say, well, if we allow it, then it could potentially negatively impact public health. If we don't control it, then people can potentially, harm themselves, and as a result, it will be a problem. And so that's some of the stances that the court will take why they say that there is no allowance for it, even if there is consent. Another reason is safety. They say, again, from a safety perspective, you cannot consent for certain types of acts. So the state may say that you can't consent to being, you can't consent to being whipped or flogged to the point of having, drawing blood or having certain types of marks, because from a safety perspective, the state may look at that as it negatively impacts safety. And if we allow for it, it will open the floodgates for people to engage in the same sort of activity and put a strain on other systems. So that's the other reason why the court will say why that is another reason why BDSM and kink is criminalized. And the last part is the morality. So again, the morality part really is not necessarily rooted in a practical issue with respect to how society functions, but more so about principles of what is right and what is wrong. Some of these issues in morality go down to certain types of religious beliefs and how it may potentially impact jurisprudence, certain aspects of what people believe is right sexually and what is not. And so those things can control the morality and exactly how the court can really make decisions based on that. And again, the way how our Constitution reads is that the court should not really be the arbiter of morality. However, in a way, the court acts as the social basket, so to speak, of our country. So when you go to court and they're interpreting the law and what it says, the court can say, well, for moral reasons, we think that it has to be done this way because it could potentially cause these other issues. So sometimes sometimes the court may do is they'll say that, oh, well, for morality reasons, we find that there's an issue, but not only is there a morality issue, they'll tack on a safety issue or a health issue on the back end to legitimize it further. So again, it just really varies based upon what position the state takes or what the court takes in trying to enforce assault and battery statutes in each particular state. Now, I want to use an anecdote because it's very important to give some real context to this. So there we have a baseball pitcher. His name is Trevor Bauer, and he was accused of sexual assault in 2021. Trevor Bauer was, a very good pitcher for a very good baseball team, and again, was up and coming, had a very good record, and had a very good career. And due to this incident, it did ruin his chances at potentially being a star in the baseball world, a bigger star than what he currently was. Essentially, Trevor Bauer had indicated that it was consensual, kinky sex that was going on. And there was an instance in which a female partner that he was engaged with said that in their lawsuit that, no, he was abusing me. It later was determined that it was indeed consensual, kinky sex. The court had found that there was clear consent and compliance with consent based on evidence, which was text messages, emails, and also other sort of material evidence during the court case. And as a result of that material evidence, the prosecutors actually did have to drop the charges in February 2021. And then in October of 2023, there was also a civil case that was settled in relation to the same situation. So again, assault and battery can have a very large impact, but also, again, engaging in consent can mitigate some of the issues that you may run into with respect to some of the assault and battery charges that you may see on the criminal side of things. So you need to, again, engage in clear communication and have clear agreement about what you wish to do. So that way there is no gray area with respect to whether or not something is considered abusive behavior or considered sexual assault versus consensual kinky sex. And please keep in mind that consensual kinky sex, or CKS as some people call it, is completely different than sexual assault, because sexual assault is about exploitation versus consensual kinky sex is about not exploitation, but both parties agreeing to engage in certain types of sexual conduct and having clearly defined guidelines about how that is set to occur. So again, you just need to make sure that there is a clear distinction and a very clear path forward to avoid any lack of ambiguity in this situation. So how do you navigate this space? Because again, it may seem a little bit scary that you could potentially be brought up on those charges, and there may be scary that maybe there's a lack of clarity about what those things are. So again, here is some guidance on how to move forward and not have fear about negotiating or navigating the space. Have fries, have fries. Talk about and negotiate your type of activities specifically and very, very clearly. Remember that consent is always a must in every single circumstance, every single time for every specific activity. Remember to also use RAC, which is Risk Aware Consensual Kink, or SSC, which is Safe, Sane, Consensual, or any other safety and consent systems to establish boundaries, safe words, and other precautions for play. And as Peg mentioned, you got to remember to look at the consent and risk profile. And then in addition, play with partners that you trust and be aware of your surroundings. Again, you need to make sure that if you are playing with people, and granted, pick up play is fine, right? But you have to be mindful that when you're playing with people, that you are very aware that you trust this person, that you know this person, you're aware of your surroundings and where you're playing at, and that you know what their limitations are prior to engaging in the scene. So that's really important with respect to how things should go forward and how things should really look with respect to negotiation to prevent any sort of assault and battery charges on the back end of a kink or a play scene. Now, before we head up to the public decency laws, I wanted to address a question that was posed by Peg in the chat. And she asked, does this mean written consent is best to protect ourselves in the eyes of the law? So I will say that to some extent, yes and no. So in some respects, written consent is better because it is clearly defined and laying things out. I will tell you that written consent also is sometimes best because you have evidence that you can potentially use to protect yourself in the event there is a lack of clarity. So there's a reason why, even with respect to how people approach contracts, and I'll use contracts as an example. Contracts, again, is a result of a negotiation, and it is also a result of a series of conversations that have happened for guidelines to be set about what's to occur, how things will occur. So when you have written consent, it really removes a lot of ambiguity, and it really makes it very clear for both parties what can and cannot be done. Now, what I will say, though, is it also can potentially be used in a way that can potentially backfire. So you have to be mindful of how you communicate with your person that you wish to play with or engage with when you're engaging in written consent. So if you're texting someone back and forth about what you wish to do, you can, again, use that as a way to have very clear ways to guide your communications. Or for instance, if you decide to text back and forth or email back and forth about what type of activities you wish to engage in, it's protective in the sense that you have a written record of what will and what will not go on, or what can and cannot go on, right? And then also be able to frame the discussions for later on if you need to revisit it or make adjustments. So it is the best way to protect yourself, and also the best way to ensure that your negotiations are solid and that they're all cohesive. Because sometimes when you're writing something out or you're putting something to paper, you may consider something that you probably may have not thought about in the course of speaking person to person. So to answer your question, Peg, yes, written consent also sometimes is better to protect ourselves. It may not always be best, but it is better than having absolutely nothing, and sometimes quite a bit better than only having oral communications and conversations. So thank you very much for your question. Now, with respect to public decency laws, which is our next segment, what are they? So public decency laws are laws that are designed to outline appropriate conduct while in public. And so with respect to those public decency laws, it can be like, well, how do you dress? What type of language can you use in certain spaces? And what type of actions can you engage in certain types of spaces on the street? And where those things can occur at. So I'll just use this as a very example. If you're going to Folsom in San Francisco, right? Public decency laws in San Francisco engaging in that event may be quite a bit different than if you were engaging in, Southern Decadence in New Orleans, or if you're engaging to Folsom Street East, primarily because there's a difference in jurisdictions and there's a difference in the law and what can and cannot happen. There are some places where you can engage and play in public so long as you have everything covered. There are some places where you can't engage in any play in public. However, you can walk around in a jock strap and you can have, your rear out. So again, it varies from place to place. Before you go anywhere, I always advise people to know the public decency laws of the place that you're going, or ask a person who's local to that area what those rules are so that you're not caught off guard and that you don't run afoul of anything. Because public decency laws can mean the difference between someone being getting a slap on the wrist and getting a simple fine, up to be considered a sexual predator or being put on a registry. So again, you just have to be very, very cognizant of those things when you are engaging in any sort of public play, or if you're deciding to go to certain places and being around certain types of people when you're engaging in certain types of events, and no matter where you are. Now, what types of activities are affected? So here's the 5 big ones that I often see in my survey of the public decency laws that we have around the country. And I'll kind of break them down just so that way there's a little bit of clarity as to why these specific activities are always the most impacted. So the first is impact play, Again, we're going back to that assault and battery conversation. If we're talking about assault and battery, the state has an interest to protect its citizens. And so if you're engaging in impact play in public, depending upon the circumstances, you could get in some sort of trouble if you are not appropriately gauging where you're playing at. So for instance, it's about venue and your location. If you're at a Folsom Street East, or if you're at Folsom in San Francisco, you can do impact play in public subject to certain limitations, right? However, at the same time, you can't do that in other places at other events because it has to be behind closed doors, right? So you got to be mindful of that. Another one is nudism or naturism. There are generally a lot of laws and a lot of jurisdictions about how you can be dressed or undressed. And the state of undress usually is more actively addressed than the state of dress. So, for instance, with respect to nudism, a lot of times people will say, well, can you be dressed this way or dressed that way? There are certain variances also in the law from place to place about how people can show up. So say, for instance, there are some jurisdictions in the United States where people can be topless. Men, women, non-binary people, anyone could be topless. And there's no laws forbidding it, or there's laws that provide specific allowance for it, for artistic purposes or what have you. There's other places where you must remain fully clothed. And if you're not appropriately dressed, it could have certain legal ramifications. There are also specific designations for certain types of beaches or certain public places of accommodation. You have to be aware of that, and those laws also can affect those as well. So you just have to be mindful that with respect to dress or the state of undress, there are laws that can also guide that. Fetish attire and uniforms. So fetish attire and uniforms also are subject to public decency laws, and there's a few reasons for this. So in certain other countries, wearing certain uniforms, depending upon what the uniform is illegal. In the United States, you can wear a uniform or you can wear certain types of fetish attire in public. But one particular example that often people will see is, say, for instance, you're into, law enforcement uniforms or military uniforms. There are specific laws that govern how people are supposed to wear those uniforms. So, for instance, I live in Georgia. I know for a fact that living in Georgia, I cannot wear a law enforcement uniform that resembles anything in the state of Georgia, because essentially it will be impersonation of an officer. So it's public decency and also impersonation of an officer that's a concern. So you have to be mindful of that when you decide to wear a uniform or certain types of fetish attire, there may be laws that can interact with that as well. Exhibitionism and voyeurism. Again, this is about public display, about a public display of sexual activities, and you got to be very careful with this. And the same is also true with water sports. Both of these activities are very highly regulated, and oftentimes people run afoul of public decency laws with respect to these two, because generally speaking, public nudity or public sexual activity, and even also public urination, are seen as crimes of sexual misconduct. So in certain jurisdictions, if you are actively engaging in water sports in a public place, or if you're actively engaging in exhibitionist or voyeuristic activity in public, you could potentially run afoul of these rules and be put on a sex offender registry. So you got to be very, very careful with respect to exhibitionism or voyeurism or water sports if you're in a public place. What I will tell you is that with respect to public decency laws, again, the key word is public. So what is considered public versus what is private? If you feel as though a place is public, and you know that people who are considered not a part of the community could potentially interact with that place, then it is considered public for purposes of the law and purposes of public consumption. The other thing is that there also is standard language in the law about what is considered public versus what is considered private. So in the law, what we say is privacy, or what is considered private, is considered the place in which a person has a reasonable expectation of privacy. So for instance, I'm in my home. No one can see inside of my house. I have a reasonable expectation of privacy within my home. So therefore, the public decency laws do not apply so long as no one is able to see inside of my home what is going on. Now, if I have my windows open and I have my curtains drawn completely open, people can see what's going on, I have no expectation of privacy. Now, granted, the rules are still a slight bit different because the activity is happening within the home, But there's still a notion of what is within the realm of the expectation of privacy. And if it's happening within that realm of privacy or that expectation, it's generally considered private. But if there is no reasonable person that can find an expectation of privacy, then it will be considered public. So you just have to keep that in mind. Now, keep these things in mind also. Again, you got to be aware of your surroundings. Check the place that you're traveling to and speak with the person that is locally in that place to know exactly what's going on. If you don't have anyone that you know, there's plenty of resources available online for you to check the law that's applicable in the place that you're going. Generally, again, there's more freedom in places where there is an expectation of privacy. You have to be mindful that the expectation of privacy is the thing that can save you in the event that public decency laws are something that you are very, very concerned about. And then lastly, with respect to public decency laws, there are some decency laws that are rooted in health and public safety. Again, this goes into line with why BDSM and kink can be criminalized by certain states, certain jurisdictions, or certain courts and how they interpret the law. So again, with public decency, keep it private if you want to avoid any public decency laws and running afoul of them. Now, with respect to the constitutional law, generally rights regarding sexual expression are subject to constitutional protection with limitations. And the most constitutional problems that people will run into is that right to privacy, equal protection under the law, substantive due process, and the freedom of speech. And the freedom of speech entails the freedom of exercise of religion, the freedom of being able to dress, the freedom of actively speaking or making written press. Again, those things are all included in the freedom of speech. So those are always implicated when you're talking about any sort of criminal misconduct or any sort of concerns with respect to how your rights are able to be protected. Now, the constitutional law has had quite a bit of changes. And so for historical context, pre-Lawrence versus Texas, most sexual conduct between non-heterosexual consenting adults was criminalized due to sodomy laws. So prior to Lawrence versus Texas, and again, I'll explain Lawrence versus Texas later, but Lawrence versus Texas was ruled on by the Supreme Court in 2003. So since 2003, the rules have been different. But prior to that point, again, there were a lot of restrictions and the states had full reign to prosecute according to those rules, even if the rules were not necessarily abiding by trying to protect people's equal protection or substantive due process rights. BDSM and kink were treated as mental health disorders according to the old psychological diagnostic manuals. So when they did decide to prosecute, a lot of times prosecutors will also look at the mental health arm as a way to either A, try to criminalize or prosecute the person and try to get them either confined involuntarily to a psychological institution, or what they would do is they would try to label people as unfit. And this was according to what the DSM-3 was and the DSM-4 to some extent, the earlier versions of the DSM-4. But as time has changed, so has the rules and regulations regarding that. So if you're looking at how things have changed from Lawrence versus Texas to now, that use of mental health disorders to try to diagnose and in addition to criminalizing people has also changed as well. And then also, it was not possible to consent to bondage and domination or sadomasochism as sexual activity due to those sodomy laws. Again, sodomy laws were very clear to some extent about only allowing very limited sorts of sexual conduct and activity. So for instance, there were some laws that were on the book prior to Lawrence versus Texas, and some states still have them, that essentially it used to be that if it wasn't sex for the purpose or sexual activity for the purpose of procreation, it was considered sodomy. If it was not between a man and a woman, then it was considered sodomy. Or if it wasn't, even the type of relation. So for instance, if people were engaging in penetrative sex that was not missionary, certain laws in certain states would actually consider that to be sodomy as well. So you have to be think about, at one point in time, there were a lot of things that were considered to be criminal activity in the context of sex and sexuality. And to some extent, the landscape has changed, right? However, at the same time, there are still some things that really have not. So in 2003, Lawrence versus Texas did change a lot of these old rules and how the ways courts, law enforcement, and also judges and even regular people took a look at sex and sexuality in the United States. And it's hard to believe for some people that in 2003, 21 years ago, this ruling took place. So essentially, the story of Lawrence versus Texas, and I'll just kind of shorten it for purposes of content, is that at some point in the state of Texas, Texas had a sodomy law that made it illegal for any person of same-sex attraction to have sex with another person, and that the police were authorized to come to someone's home and arrest them for engaging in this sort of act. And as a result, police were able to arrest and try to prosecute Tyron Gardner and John Lawrence. So these two men were basically engaged in consensual same-sex sexual activity in the state of Texas, and they were prosecuted. What happened was that the state court essentially tried to uphold the conviction. And then what happened was the case went through its multiple iterations based on violations of the Equal Protections Clause and the Due Process Clause. So what happened was that the U.S. Supreme Court in 2003 said that the Texas law making same-sex sexual conduct a crime for two consenting adults violates the Due Process Clause of the Constitution. And it said that Lawrence and Gardner were free as adults to engage in private sexual conduct due to the Due Process Clause. So as a result, due to that, Tyron and John were able at that point to then engage freely in sexual conduct. In 2011, John Lawrence, who was the plaintiff in that case, actually did pass away. And I'm not exactly sure about Mr. Gardner, but as a result of this case lays the foundation for a lot of rights that the LGBTQ community and also the kink and BDSM community have now. The foundation of most of our rights and protections in terms of sex and sexuality derive from this case. And without this case, it's very, very hard to even imagine a world without it. So when we talk about the importance of voting in elections again, this case is one of the few cases that often is on the slate of cases that are potentially in danger of being reversed upon an appointment of a new Supreme Court. And also, in addition to that, with the margin in this case, if you notice that the margin in this case was a 6-3 decision. This decision was not a unanimous decision in the Supreme Court. So the question becomes, in 2024, how would the court rule on this same case if the facts were exactly the same? Which is why I say it's important to keep in mind that elections and the results of those elections have a very big impact with respect to our Supreme Court and how that Supreme Court can even interpret the law moving forward. So now, after Lawrence versus Texas, and I see that we have a little bit of a difference in our slide today, is that consenting adults can have sexual conduct and sexual contact irrespective of sexual orientation after Lawrence versus Texas, and that states cannot enforce sodomy laws based on two consenting adults of whatever orientation. You can't do it if the person is gay or straight. They have the right to sexually engage with whoever they wish to engage with. Also, be aware that some states still have sodomy laws in the books. There's a total of 12 states that I know specifically still have them on the books, and most of them are in the South. And they're listed here to some extent, but I would say that you got to be mindful again of where you are, and remember that BDSM and kink activities are not specifically constitutionally protected as a result of Lawrence versus Texas, which I'll show you in just a moment, because just because we do have Lawrence versus Texas, it doesn't mean that our protections are completely sealed in stone. So this now takes us to the general viewpoint about BDSM and kink after Lawrence versus Texas and the more modern approach. So there was a case called Doe versus Rector and Visitors of George Mason University that was ruled on in 2016 in the Eastern District of Virginia, which the Eastern District of Virginia has been seen as one of the more moderate jurisdictions with respect to how they ruled on cases. The Eastern District of Virginia made a decision to say that basically that there is no constitutional protection for BDSM and kink activities as a matter of course. And the specific language in the case, and I have it stated on the screen, it says a legislative restriction on BDSM activity is justifiable by reference to the state's interest in the protection of vulnerable persons, i.e., sexual partners, placed in situation with an elevated risk of physical harm. So again, we're taking a look again at the court trying to rationalize the basis as to why BDSM and kink are not constitutionally protected, saying that for health and public safety reasons, we cannot legitimize it. And in the case of Doe versus Rector and visitors of George Mason University, the case was basically about a student who was at the university, and there was allegations of sexual assault with that student who was engaged in consensual BDSM with another student who was enrolled at the university. After the case was ruled upon, the court still said that even if there was consent, if we could find it, that still does not create that protection. So it goes along with that traditional viewpoint that consent is not a defense, and that specifically there's no constitutional protection for BDSM and kink in the current world that we live in. So with that being said, you got to just keep in mind that as you work about and negotiate and play, that there is no constitutional protection, but the law and the state of the law is still kind of open with respect to some of these questions. And while there is no specific protection, you still do have some other ways to try to protect your rights as a BDSM and kink practitioner. And again, it just varies by state what that level of protection may be based on how it interprets the law. Now, in terms of how the courts usually look at this, constitutional protection often is argued for BDSM and kinksters under the substantive due process framework. Basically, the protections are rooted in sexual privacy. In a lot of cases that there have been about BDSM and kink in terms of being practiced and whether or not there are protections are rooted in the idea that there has to be some sort of substantive due process rights that are there that must be protected, and that sexual privacy and sexual freedom are the cornerstone that must be followed in order for us to have those rights continue to go forward. Lawrence versus Texas continues to be the landmark case and the seminal case that protects most LGBTQ plus, kinksters, BDSM practitioners, and you name it, because it literally defines the state. It literally defines what the state can and cannot do, and what the state can and cannot do with respect to creating laws about types of sexual activity. Again, though, the state has a compelling interest to protect citizens from physical harm or possible exploitation. So if there are allegations of physical harm, abuse, or exploitation due to, sexual trafficking or what have you, then the court can still say that there is, even with consent, even with their evidence of being consent, that BDSM and kink cannot be a protected activity. So again, you got to keep that in mind as you're out here playing and you're negotiating with people. Don't be afraid to do it completely, but still at the same time, the way how the landscape does look is that their protections are very, very limited, and it is on a case-by-case basis. Now, we go then to the civil considerations. And the civil considerations of BDSM and kink are kind of, again, rooted in that same notion of exactly what are the things that BDSM practitioners and kinksters do that also kind of put us in harm's way with respect to civil liability, and potentially also what could be things that we need to look out for in those spaces. So the first is contracts, which are agreements between parties to do or not to do a specific thing, private lawsuits that can sometimes arise due to the assault and battery charges that we've mentioned earlier, and then civil rights and discrimination, which have constitutional implications on its own. So what is a contract? So the simple definition of a contract is a written or spoken agreement. And again, that is the basic definition of a contract. Now, in the legal world, our explanation of what a contract is a little bit more nuanced and a little bit more complex. But at the bottom level and at the basic level, a contract is an agreement between two parties to do or not to do something. Now, there is a leather and BDSM definition of what a contract is and a legal definition of what a contract is. And what I've decided to do is to highlight the parallels and the differences between both so that there's a little bit of clarity for everyone in the community about how there is some intersection, but how these two are completely different, and why oftentimes leather and BDSM contracts are not always honored in the court of law or in the legal space. So in the leather context and in the BDSM context, a contract is an agreement between a dominant and a submissive built upon consent, expectations, rules, protocols, and it sets parameters of the physical and social dynamics on a continuing or temporary basis. So that's the leather and BDSM definition of what a contract is. Now, the legal definition of a contract, from what I gathered from my research, is that it is an agreement between parties with adequate capacity, creating mutual obligations that are enforceable by law by mutual assent, and a valid offer which is accepted by adequate consideration. So I've highlighted the words here that basically talk about the things that parallel in both worlds. So in order for you to have a contract, whether it's in leather and BDSM or in the legal world, is that there has to be an agreement. Both people in the agreement or both people who are parties to the agreement have to agree to the terms and conditions. And they both have to mutually assent and have the same understanding. It has to be a mutual obligation which has the roles, rules, and protocols and set parameters that are specifically set as to what person should or should not do. And on top of that, again, it has to be enforceable to some extent. So in a leather and BDSM context, those rules and standards are enforceable by the dominant and also by the submissive to some extent. In the legal world, those rules and guidelines are also enforceable each by each party, because if someone doesn't do something within the context of that contract, the other person is liable for the breach of that contract. Now, with leather and BDSM contracts, however, as I mentioned, they're generally not enforceable in court. And there's multiple reasons why. The reason why generally leather and BDSM contracts are not enforceable in court are because, again, it has to deal with the idea of consensual kinky sex, or anything related to sexuality is rooted in privacy. So it's really hard for the court to try to be the arbiter of what people agree to privately in their own bedrooms or play spaces. It's very, very hard to do that. But there are some provisions that are enforceable and can be enforceable within a contract that is a leather or a BDSM contract. So provisions related to housing and finances generally are always usually seen as enforceable if you're looking at a BDSM contract. And the reason why, even if you have a 10-page contract and there's a paragraph talking about housing and a paragraph talking about finances, the reason why those two provisions could be enforceable is due to the doctrine of what we call severability. The doctrine of severability basically allows a court to review and interpret a contract and not enforce the parts that are unenforceable or void for public policy reasons. But it allows the court to also, for purposes of equity and ensuring that parties are made whole according to the terms of the contract, they can still enforce provisions related to finance or related to housing. So I remember I read in my studies and in my review of the materials for this presentation that there was a case some years ago involving a BDSM couple in the state of New York. And the couple essentially had a contract. Part of the contract talked about the submissive being a houseboy to the dominant. And essentially what happened was that the agreement had provisions related to housing. And basically the dominant agreed to provide housing to that houseboy in particular question. So what happened was that when the contract came at issue, because the dominant was trying to make the submissive move out due to the breakdown of the relationship, the dynamic still had that contract provision regarding housing. And the court in New York actually was able to enforce the housing provision, which allowed the submissive to remain in the person's home, the dominant's home, for another series of months, subject to them paying rent. So in other words, there's still some allowance and creation of legal obligations, even that you can find in a BDSM or a leather contract, and you can still find those in there. So you got to be careful and ensure that when you decide to create leather or BDSM contracts, that you separate those matters from each other, right? The rule of thumb is separate those things, because in the event that you just have to go to court or there's some sort of legal situation, you don't want your leather and BDSM contracts to be the source of public consumption, because when you have a case, it's public record. And so the terms and conditions of that agreement could be the cause or concern for an order that the court would have to probably take a look at. So just please be mindful of that when you're drafting and preparing your leather and BDSM contracts. Now, with respect to private lawsuits, what can people sue for? Again, everybody wants to sue. I remember when I was in law school and I went to Emory for law school, the big thing that we also often talked about was lawsuits are the candy for the person that's hurt. And some people call it that. And oftentimes when they say you want to sue, you sue for everything. So what happens is that you can sue for multiple things. Oftentimes when you sue or when people sue in BDSM and kink dynamics, they sue based on these 4 large areas. Normally the false imprisonment, assault, battery, and defamation. So normally the reason why you run into the false imprisonment charges in terms of the civil lawsuits is normally in cases where there's bondage or there's some sort of confinement. Sometimes false imprisonment, the terms of false imprisonment charges are often that the person is confined and they're confined in a way that's different than the terms and conditions that were called for. So when you're dealing with false imprisonment charges, you got to be mindful that the person was confined, they were not able to leave, and they didn't have the option to do so. With assault and battery, we talked about those earlier, and it's about the fear of apprehension of harm and the actual harm itself. And then defamation, which is making a false statement, whether it be written or whether it be verbal, and publishing it to the public for consumption, knowing that the information is false or without regard or have reckless abandon for the truth of what that statement is. These public lawsuits and private causes of action are something that you do have to be mindful of when you're dealing with kink and BDSM activities. And so when you're dealing with people, that part of the way how you avoid these private causes of action are by negotiating very clearly and ensuring that your negotiations are airtight. So that way there are no claims for false imprisonment, assault, battery, or defamation. Now, the other part is civil rights. And civil rights is an unfortunate truth. Again, we live in the United States, and unfortunately, discrimination is still a part of the world that we live in. And also, it is still something that is alive and well in 2024. And people get discriminated against for a myriad of reasons. But for BDSM practitioners and kinksters, we have issues with respect to discrimination if we end up being publicly found out in some instances. Some people do worry about being outed or being made public. And so as a result, there are some concerns about whether or not people have those protections on a civil standpoint due to the potential for discrimination. So I will just say that it is possible for someone to get fired or denied access to public accommodations as a kinkster or someone in a BDSM dynamic in most states. There are some states that people are not provided that as an option. There are some instances that I actually know people that have been let go from their employment or fired, or they've been denied certain sorts of public accommodations, being able to go to certain places because they are publicly known as a kinkster. And it's unfortunate and it's not particularly right. But at the same time, some of this also has to do with how the United States looks at who is someone who's considered a protected class. And unfortunately, as we'll find, you're not a protected class as a kinkster. So most laws provide protection from discrimination based on the protected class designation. The Civil Rights Act of 1964 specifically prohibits discrimination in public accommodations, healthcare, and also hiring. And each of those have different titles. So if you're talking about, discrimination in employment, that's Title VII of the 1964 Civil Rights Act. If you're talking about Title IX talks about health, specifically educational institutions. And so when you're talking about kinksters are not considered a protected class because the law was not written specifically for us. So there are certain other ways that people could be considered a protected class. So for instance, if you are of a racial minority, right, the law will look at you as a protected class. If you are considered to be a woman or of a non-binary designation, depending upon your state, you're considered a protected class. If you're LGBTQ, depending upon the state and also the guidance of the Department of Justice and how they interpret the Civil Rights Act, then you'll be considered a protected class. But as a kinkster, because it's not considered to be a specifically marginalized group, then you're not considered a protected class. What I often will tell people is that in reality, however, the majority of people who are BDSM practitioners or kinksters usually do fall into being a part of a protected class due to another identity or intersectionality. So you kind of have to keep in mind exactly what could make you a protected class versus what would not make you a protected class. But just dry along, so if you're a kinkster or a BDSM practitioner, you are not considered a part of a protected class alone. You need to usually fall into another protected class to provide you some sort of protection under the Civil Rights Act of 1964. Now, who is covered? The current laws against discrimination are based on race, color, religion, sex, national origin, and they're also, depending upon other groups and other states, they may vary. So for instance, in the state of Georgia, where I'm currently residing, we have no state law specifically about who is considered to be protected against discrimination. And the state also does not have a specific public office that handles discrimination. But if you go to states like New Jersey, New York, or Pennsylvania, they have state commissions for human rights or anti-discrimination commissions that are at the state level that can also have either more expansive allowances or more expansive listings of people who are considered protected classes. Also, the other part is transgender protections widely vary state to state. Now, again, the Department of Justice has had some guidance on this and has gone back and forth based on the administration. However, at a state level, because each state varies and it changes from state to state, those protections vary very widely. And those protections could either protect someone from having housing, protect someone for having housing or having a job, to absolutely having no protections at all. It just widely varies, and you just need to know your state and exactly where you're located and talk with a legal practitioner to fully understand the scope of what rights you do and do not have in those places. Now, who to call if you are discriminated against? And in the event that you do happen to run into someone or a public entity or even a private entity that decides to discriminate you on the basis of you being of a particular protected class, remember that we have the National Coalition of Sexual Freedom, and on that website, on their website, the National Coalition for Sexual Freedom actually has a tool, and it's the Kink and Polyamory Aware Professionals Directory. On their website, you actually can look up lawyers who practice in whatever state that you are located in that are self-identified as those who provide services to the polyamorous or to the kink or BDSM communities. And if you go on their website, there actually is a tab for you to find that information. So in light of that, use those resources. Those resources are very, very helpful. And also, again, they'll inform you of your rights in the event that you reach out to them and contact them. But please keep in mind that if you reach out to any professionals on the directory, that in order for there to be a full creation of a attorney-client relationship, you need to retain their services and make sure that you speak with them about your potential legal problem and also how to retain their services in that process. Now, in closing, because I do just want to make sure that and I'm also glad that Peg actually didn't mention this, because Peg did say be careful using the directory. Peg did make a point. The people who are on the directory, or the attorneys or professionals that are on the directory, are self-identified. And so sometimes they do need to be vetted. But do keep in mind that, again, when you look at that list of professionals, call and speak to each person on that list to ensure that you have the right legal representation for you, because one person's attorney may not be another person's attorney. Just find the right legal representative for you in your jurisdiction. Now, in closing, because I sense that there are not really that many questions based on today's presentation, and also knowing that there has been a time change last night. I do want to definitely thank everyone for joining us today for today's discussion. And if you do happen to have any questions outside of this session, you can gladly send over your questions directly to me. Here is my contact information. So you can contact me on FetLife, X, or Twitter. Facebook, and also on Instagram. And I will be available to answer any questions that you have about today's presentation. And again, it was a pleasure connecting with every last one of you, whether it be in live time or if you happen to catch this later on. And again, thank you so much. And I hope that you've learned a lot today. And be safe out there. Remember, vote on Tuesday because our democracy depends on it. Y'all have an awesome afternoon, and I will see everyone later. Bye.